And we have
Yeah,
Midwinter on now, so we'll go ahead and bring him in. So
perfect.
he's a attorney at Kennyhertz Perry LLC. So first off, Mitt, thank you for taking the time tonight.
No problem. Thanks for having me on, guys.
So first off, if we could just have you basically overview from your professional perspective with what's going on in the Pac-12, the litigation that has taken place so far, and where you might see this headed.
Yeah, I mean, it's a pretty unprecedented situation. With in conference realignment, with two members being left in a conference, then suing that conference that they're still a member of. Basically to have control over what is left of the conference. Um, I'm not surprised that Oregon State and Washington State took that approach. If I was in their shoes, I would probably do the same thing. But it's just a very unusual situation. Usually in conference realignment, when lawsuits are filed or lawsuits are threatened, it is a situation where a few schools leave a conference, and then the conference might threaten to sue those schools, or might threaten to sue the conference that the departing schools are going to. But I can't ever think of another situation where the remaining schools have sued the conference and their commissioner of the conference that they remain in when all the other schools are leaving the conference. So it's a really unusual situation.
Mitt, do you feel like this is something that the other 10 schools just did not expect or just plan for in their doomsday, look at conference realignment?
Yeah, I mean, I obviously don't know what they were thinking what would happen when they left, but I assume they didn't think that Oregon State and Washington State would sue the conference and the commissioner to basically have control of the conference, alleging that the 10 members that left were in breach of the conference bylaws at the time they announced they were going to leave next year. I think they probably also thought that Oregon State and Washington State would end up in another conference, most likely, Big 12 or whatever conference that would have been. So I probably think that they assumed that those two schools would find a landing spot. So that probably played into some of their decision making as well. But yeah, I highly doubt that they thought that they would find themselves in the litigation that they're in now.
Mitt, can you kind of explain what UDub, with the lawsuit that they just filed, or the restraining order, to me and to most football fans who, we can be a little bit blockheaded at times. And sometimes when you have big words like erroneous and stuff like that getting thrown around, it can get a little bit confusing. It really turns into that meme of like, cool story, I'm happy for you, or sorry that happened. Can you kind of explain it like I am an idiot to me and to all the fans about what UDub did and how that's going to affect the litigation moving forward?
Yeah, so what UDub filed is a motion to intervene. So right now, the only parties in the lawsuit are Oregon State, Washington State are the plaintiffs, and the defendants are the Pac-12 and the commissioner. So UW and the other 9 schools that are leaving are not actual parties to the lawsuit. So what UW filed is called a motion to intervene. They want to intervene to become a party in the lawsuit. And basically they're arguing that they should be allowed to intervene as a party in the lawsuit because no one involved in the lawsuit, especially the conference and the commissioner, are not adequately going to represent UW's interest, because they're saying this lawsuit affects us. It's going to have an effect on us. And there's no one that's currently a party in the lawsuit that's going to adequately represent our interests in this lawsuit. And so in addition to that, they filed their motion to intervene. And then assuming that gets granted, they also filed a proposed motion to dismiss the lawsuit for a number of reasons. So they're hoping that the court, number one, allows them to intervene in the lawsuit as a party. And then number 2, grants their motion to dismiss the entire lawsuit.
And what they said too was the crux of the Pac-10 case is that the Pac-2 are using an erroneous interpretation of the Pac-12 bylaws per court docs. So is it kind of like a he said she said type thing here over the bylaws?
Yeah, so that's really kind of assuming it gets to the merits of the case. That's really what the heart of the case is about, is what do the Pac-12 bylaws say. So Oregon State and Washington State are taking the position that the 10 schools that announced they're leaving have breached the conference bylaws because they announced they're leaving prior to August 1, 2024. The other schools that have left are taking the position that they have to actually announce they're going to leave before August 1, 2024 to be in breach of the bylaws. So they're saying we would have had to say we are leaving the conference now or tomorrow, sometime before August 1, 2024 to actually be in breach of the bylaws. So it's going to be, they're asking the court to interpret those bylaws, and Oregon State and Washington State are taking one position, the other schools are taking an opposite position.
Yeah,
And
so
talk about
Washington.
sorry, Connor. Talk about the precedent though, also in this case, where obviously, prior USC and UCLA were the first two schools to leave, and then essentially the Pac decided to keep them out of board matters as well as Colorado. Can you explain just the precedent that's going on with those three schools that announced their early movement before the Pac blew up?
Yeah, from what I understand, when those three schools announced that they were leaving the Pac-12, they were no longer involved in the decision making for the conference. And I'm not sure whether that was something that was official, that the conference told them they can no longer be part of the meetings, or if they just sort of, out of common sense, decided, hey, we're just going to sit these meetings out and let you guys decide the fate of the conference, how the conference is going to operate going forward, because we're no longer going to be part of the conference. But under that same precedence, kind of what you're getting at, if the 10 schools that are leaving, if they follow the same precedence that was set there, they would sit out the board meetings and let Oregon State and Washington State, determine the fate of the conference going forward.
And can you explain the process, both with mediation and then discovery? Because it sounds like UW is wanting to enter into a mediation process with Washington State and Oregon State in an attempt to avoid discovery. Is that correct?
Yeah, there's actually mediations already going on amongst all the schools. So in mediation, there's a mediator, and in this case, it's a retired judge, which is pretty common. And so the mediator's job is to try and reach some sort of resolution or settlement for the parties to agree on. And as part of that, the lawsuit gets dismissed. Each side goes their own way. But they sign a settlement agreement. It says, Oregon State, Washington State, you get this, or the other schools, you get this. So they're already involved in that process. And so that process can go on concurrently with litigation, and it usually does. So just because there's mediation doesn't mean there's not going to be discovery. You can have both things going on at the same time.
Yeah, and there was a deadline. Obviously, October 13th was a discovery deadline. So I guess how does this mediation, does that push that back in terms of, because obviously these universities do not want discovery to happen and have that dirty laundry spill out into the public sphere.
No, the mediation is not going to have any effect on the discovery process. That's going to be, so right now, I think on November 14th, there's a hearing on the preliminary injunction. And a lot of times courts will stay discovery until they rule on that preliminary injunction motion. I haven't looked at the docket on this case to see if the court put in a stay of discovery until it rules on that motion. I assume it probably has. So the hearing on that motion is November 14th. There's also a hearing on October 25th, assuming that UW, its motion to intervene gets granted. It wants to have a motion on its a hearing on its motion to dismiss on October 25th. So I think once those two motions get settled, whether the court grants or denies them, then at that point, that's probably when discovery would happen. And when a hearing on those types of things takes place, you can take a few weeks or even a month for a court to rule on those types of motions and draft its order on that. So I would guess that discovery could maybe happen, early December, sometime around there.
So it sounds like then that this has a possibility of extending out, 6 months even further, depending on how far these universities want to take it. Is there a chance that this isn't solved within, the next year or so when a lot of these teams are leaving to join their new conference? And if that's the case, how does that affect all of this? Can, that money go back to Oregon State and Washington State if they win this, but they win it 2 years from now? How does that work?
Yeah, it's possible it could drag on that long. I assume that, both sides would want to have this whole thing resolved before that point, but assuming that the litigation drags on past the date of August 1, 2024, and the other schools have left, yeah, I mean, theoretically, I think that the assets of the conference would still, be with the conference. And if we assume that Oregon State and Washington State end up winning, and then at that point gain control over the conference and its assets, then they could do with those assets what they want to do.
I think you're pretty unbiased as anybody. I think you played your college ball at William and Mary, so back out east.
Yep.
Who do you think, from your point of view, holds the most leverage in this case moving forward? If you can kind of give us maybe some sort of crystal ball outlook.
That's a good one. I actually think that the argument on what the bylaws say, I think, to find out what you guys want to hear, but I think the departing members actually have the better argument there. Because it doesn't necessarily make sense that if you announce that, let's say you announce you're going to leave the conference in 2 years, but you don't actually leave until that date you're allowed to leave. To me, that's not a scenario where you're breaching the bylaws. I agree with the argument that you're only breaching the bylaws if you actually leave the conference before whatever date it is.
So even these tweets on upcoming schedules with the Big 12, each school had their, Cal and Stanford, welcome to the ACC, all these public tweets and so on and so forth via social media, and even letters to alumni associations within those schools, you don't think merit that?
It's possible. I'd have to see all that stuff. I haven't seen all that stuff that you just referred to. There probably could be some things out there that Oregon State and Washington State could point to and say, yeah, this is something that rises to the level of breaching the bylaws. So I'm not saying that Oregon State and Washington State don't have any arguments in their favor. In litigation like this, you never know what's going to happen, and a lot of other evidence and discovery, if it gets to that point, could come out that we aren't aware that exists right now.
Is this just like a winner take all thing, or like what would happen if, say, the court found 5 of the schools had breached the contract but 4 hadn't, or whatever the numbers on that is? Is this a situation kind of where like you have to have all of them breach the contract, or could Oregon State and Washington State win this lawsuit against half of the schools, and then the other half, it's like, well, technically they didn't meet that threshold, so then they don't have to pay out, or they get their money back or some of their assets back from the Pac-12? How does that work?
Yeah, I think something like that could be possible. And so then if we imagine a scenario where 5 schools didn't breach and 5 schools did, and so that would leave 7 schools in the Pac-12, then I guess those 7 schools would be the ones that control the assets and have the board meetings and decide what happens going forward with the conference. I think the most likely scenario is, though, there's a settlement. The assets get divided up in some manner, probably with Oregon State and Washington State getting a large portion of those assets. The schools that are leaving get, some smaller amount of those assets. And then I think there's also a question of what happens to the NCAA basketball tournament units, because those extend out for a few years. Right. And then what happens to if a team makes the CFP this year? So you still have some, undetermined financial numbers. So even if there is a settlement, there's probably going to be that settlement agreement will have to be in effect for a while to kind of figure out what's going to happen with some of the finances that haven't really happened yet.
Right.
And then can you discuss briefly about sovereign immunity and how that would affect these things?
Yeah, so sovereign immunity, it's a legal doctrine that makes it difficult to sue states, which includes state officials and state institutions like public universities. And sovereign immunity law, it's different from state to state. Some states you can sue state entities for breach of contract. Some have different ways you have to sue them for breach of contract. In some states, you can't sue a state entity at all for breach of contract, like Texas. You can't sue the state universities at all. Like if you're familiar with the Mike Leach Texas Tech case, they were able to get his lawsuit just completely dismissed because he was not able to actually sue Texas Tech as a state entity under Texas law. I don't think any of the states involved in this case have that strict of sovereign immunity law like Texas does. But there will probably be different arguments made by the departing schools about why they can't be sued, or if they can be sued, different steps that need to be taken before litigation can actually occur.
And I had an interesting question just on where law firms rank, and obviously the law firm that Oregon State and Washington State have are Keeker, Van Ness, and Peters. I don't know if you're able to kind of elaborate on where they're at in the law stratosphere, if you've even heard of them, and kind of just give us an idea of like, hey, are they like the Notre Dame law firm, or are they like the Buffalo?
Yeah, they're a very legit law firm. So I used to live in San Francisco for 10 years, where I went to law school, and I practiced law out there for about 8 years, and that's where they're located. Very good reputation. They're like numbers wise, they're not a big firm in terms of the number of attorneys they have. They're a boutique firm, but they're very well known, very good attorneys. So they're a very legit law firm. So you should feel good about having them on your side.
Awesome. Well, really appreciate your time with explaining everything, giving us some insight on behind the scenes from your perspective with you being in the field. So again, really appreciate your time. Looking forward to staying up to date on the hearings as we see them moving forward.
Yeah. Thanks for having me on, guys. Appreciate it.
Hey, appreciate it, man.
Thanks, Mitt.
Yeah. Nice to meet y'all.
All right. We'll see you.
Good night.